I I would like to wait for the outcomes of review petition number 2 of 2025.
Number 8.
Number 8, item number 2, number 8.
Number 8.
Yes,
There's
my
a
lord.
similar case pending
Yes, my lord.
on appeal, is it?
Review.
Your
Review
Lordship,
petition
we do
number
not have any.
Okay, ma.
Okay, we do not have any information as yet.
Review petition number 2 of 2025.
A similar matter, is it?
Yes, my lord.
What's the case about?
It was regarding the quarry compensation.
Compensation?
Yes, my lord.
Okay. What? Is it deduction of cess or something like that?
No, unpaid quarry compensation.
Anyway, we'll find out. Ms. Jacinta Zothanmoy, learned counsel for the petitioner, has prayed for adjournment of the matter and submits that there is a similar case pending before the division bench on review, is it?
Yes, my lord.
Registered as
Number 2 of 2025.
review petition, is it?
Yes, my lord.
Number 2 of
2025.
2025. And prayed that the matter may be adjourned till the disposal of the said review petition. Mrs. Mary L. Kiante, learned government advocate for the state respondents, is present. In view of the above submission, lists the matter after 3 weeks.
After 1 month.
Your Lordship, after a week, we have to see the review whether, because this is solely the factual situation. I believe that, in my humble opinion, even though I haven't seen the review
we'll
petition.
see. Okay, list the matter after 1 week.
Yes.
Yes, my lord.
Let's see.
Admission, item 1.
My lord, in this respect, I would like to file rejoinder affidavit.
Okay. Ms. Jacinta so-and-so, learned counsel for the petitioner, has prayed for time to file a rejoinder affidavit to the counter affidavit filed by respondent number 4. Is it? By the
Respondent
respondent.
number 4. Yes, my
No,
lord.
by respondent number 4. In view of the above, list after 2 weeks,
3 weeks, my lord.
list after 3 weeks.
Item 2.
My lord, time for respondent number 6. I may be given another 3 weeks time for filing my affidavit.
Who is the counsel for the petitioner?
Senior Counsel Mr. Sheila Ramzawa.
No one is appearing. Anyway, Mrs. Zaram Sangpui, learned CGC, appearing for respondent number 6, has prayed for further time to file the counter affidavit. Yeah, have you filed?
Date we have already filed, ma'am.
Okay, Mr. Samuel L. Sangtip, learned additional AG for the state respondents, submits that they have already filed their counter affidavit. None appeared for the petitioner. In view of the above, list after 3 weeks.
Yes, my lord.
Right.
Item 3.
My lord, similar prayer in this case also.
Okay, you are for respondent number 6.
Yes, my lord.
And then Miss Caroline K. Lungoipui, is it?
Yes, my lord.
Have you filed?
Yes, my lord.
State respondents submits that the state respondents have filed their counter affidavit. Then none appeared for the petitioner. 3 weeks.
Lord,
Yes.
I'm the newly engaged counsel, by the attorney in this matter. The appellant has been in severe financial situation right now. He is trying to reach out to the respondent in terms of finding an amicable solution
I
for
can't
this.
hear you. It's echoing too much. So you are for the appellant, is it?
I am for the appellant, my lords.
Now, the appeal has not been admitted?
My lord, in this case, the appellant had admitted his liability. It's regarding money suit, appeal against
Okay.
money suit. And
Out
on
of,
eight-
my lords, out of this, 10 lakhs have been paid already. 8 lakhs is pending.
So you had paid, yeah, okay, you had paid a certain amount. I've seen this.
10 lakhs he
Uh-huh.
had paid.
10 lakhs.
Then
10
you
lakhs.
have to pay the balance amount of 8 lakhs, is it? This is
My lord,
1208
With
Yes, my lord.
interest.
Yes, my lord.
with interest. So why have you filed the appeal then?
No, that I'm the newly engaged counsel. I don't know what happened exactly with the previous counsel because this is not how things should have happened. We should have challenged the lower court judgment, but then
So
the situation was different, and then he ended
the
up paying 10 lakhs out of it. So
in
currently
the
situation
order,
is-
wait, in the order of the learned district court, civil judge maybe, you were supposed to pay an amount of maybe 18 lakhs against which you have come on appeal. But in the appeal, you're
Yes,
saying
madam.
you have paid 10 lakhs, you have paid for time to pay the balance. Then what sort of appeal is this?
Basically currently 8 lakhs is pending, and my lord, the appellant is currently in a severe financial crisis. He is just wanting to reach out to the respondents in terms of reaching out an amicable solution. Maybe, my lord, if you can refer it to mediation, then maybe we can reach out a solution in regard to this because there has been some time since he has not been able to make the payment of 8 lakh rupees. So he's just wanting to settle the matter in a way, maybe through mediation or something. If you can kindly refer it to mediation.
So
my lords.
you withdraw your appeal? Or you want to, okay, we'll refer it for mediation.
My lords, yes. We'll try out that, my lords.
We'll refer it to mediation. But when you admit that you have to pay the money and you're paying the money, then what sort of appeal is this? Let's see the judgment, impugned judgment and order. I'm just curious. What is the impugned order against which the appeal has been?
My lord, it's in the RFA number 28 of 2019, money suit number 15 of 2016, date of judgment 21/8/2019. 2019.
So what is the operative part? That you have to pay 18 lakhs?
18 lakhs with interest, my lord.
Huh?
With interest.
And after
With
filing
interest,
after
huh?
filing the appeal, my lord, on 18/1/2022, the appellant had admitted his liability, and out of this the
10
little amount,
lakhs.
10 lakhs was paid. And on 12/8/2024, he had sought for 6 months time for payment of the remaining amount. So if they want time, we can wait. And in the meanwhile, my lord, the appellant somehow managed to engage counsel from outstation, while he is liable to pay 8 lakhs with interest.
Who is
My lord, this is a pro bono matter. I have been associated with him in terms of his previous other
Let him
cases.
brought the
So
asylum.
that's a different
Why
thing.
is he going around like this? Let him just pay, even if the matter is sent to the execution court for execution. On what grounds are you appealing when you're admitting your
Ideally,
liability?
I'm the newly engaged counsel.
paying
Not
10
I'm the newly
lakhs?
engaged counsel. In terms of matter has come to me when the appellant has already paid 10 lakhs. So right
I
now,
know.
I'm just trying to figure it out if there can be an amicable solution by referring it to the
Easiest
mediation.
solution is you pay your remaining 8 lakhs with interest. And then it's
Milord,
solved.
yes, Milord, I understand that. Milord, at least if you can refer it to
Okay,
mediation.
see
we'll
if
try
you
to-
want, we can refer the matter to Lok Adalat. Maybe you can settle.
Yes, my lord.
See what his
That's all right,
difficulty
Milord.
is.
That's all right,
Okay,
Milord.
yes.
That's all right.
Mr. What's his name? Your name?
Rupesh Datta. Rupesh Datta.
Rupesh Datta. Learned counsel for the appellant is present along with Mr. Victor L. Ralte, learned counsel for the respondent.
Number 1.
Respondent number 1. The learned counsel for the appellant submits that since the appellant has paid the sum of rupees 10 lakhs in terms of the impugned judgment and order in money suit number 15/2016, the matter may be referred to Lok Adalat or mediation for settlement between both the parties.
My lord, the appellant, I would just want to make this submission. The appellant is basically a civil contractor, and the situation of PWD and other currently is not very good, because of which his payments are due for a very long time, and that's the reason he has not been able to make the payment. That's the
And
reason why I have
we'll
made the
refer it
submission
to
for
Lok
mediation.
Adalat. In view of the above submission, this court
Yes, my
find
lord.
it appropriate. Before that, which is not the submission made by the learned counsel for the appellant is not objected by the learned counsel for the private respondent number 1. In view of the above submissions, this court find it appropriate that this matter should be referred for a settlement through mediation / Lok Adalat, and matter be sent to the High Court Legal Services Committee for necessary steps. Registry to do the needful. Yes.
Obliged, my lord.
Orders, item 5.
My lord, this is a bail application. In the last court order, your lordship had requested for the court's order
Yes.
of the co-accused.
Yes. You had appeared for the co-accused also, isn't it?
Yes, my lord.
Ah. See, I wanted the order because you had prayed for the release of the co-accused based on non-compliance of 52A and 42 NDPS, okay?
Yes, my lord.
So
And
then
also-
42, so let's see whether you're 50. So all these matters were already considered by this bench, 52, So now when you have come for the co-accused for bail, so this court had observed that there's no serious violation of 52A of the NDPS Act and also 37. Okay. So now in your present bail application, are you contending that 52A has not been, same grounds cannot be taken because already decided, huh? Yes.
Yes,
So
my lord.
on what grounds have you approached this court now for the co-accused?
My lord, we had prayed on the grounds that there is no incriminating evidence against him and nothing was recovered. The co-accused, the seizing party went to Edentar to apprehend the co-accused in the Vancouver. And after that, they went to the applicant's house, and then from there they move on to where the vehicle was parked. And he is just the driver, and then they had come from Champhai to Aizawl. They had brought some vegetables and some fruits. So they've already delivered. They've already gone to their respective houses. And also the key is not with him. It's not with the driver.
Okay, so you're saying it's not seized from his possession?
Yes, nothing
It
was
seized
seized
the
from his
Of
possession.
the co-accused, huh?
Yes, my lord. And so, my lord, that he has no involvement in the charge sheet. It is alleged that the co-accused sister is the kingpin. But however, my lord, this applicant is not, it has no relationship or any business with the allegations. That, my lord, nothing was seized from him. And also, my lord, another point is the violation of Article 22. 22.2.
Of the Constitution.
Yes, my lord, of the Constitution of India.
And which section of the BNSS?
My lord, and
Okay.
Constitution of
22
India.
Constitution of India for what?
For, my lord, we had, if I may take your lordship to citation, we had submitted
No, but I'm asking you, you're coming straight away to the Constitution of India, but there must be
Yes.
violation of some section of the law in the
Yes.
BNSS also.
My lord, if I may read Article 22(2), every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of the magistrate. Nothing in clauses 1 and 2 shall apply to any person who, for the time being, is an enemy alien, or to any person who is arrested or detained under any law providing for preventive detention. Number 4, no law providing for preventive detention shall authorize the detention of a person for longer period than 3 months unless there is a proviso, my lord, that, my lord, the arrest, that, my lord, Article 22 is that the arrest itself is illegal, and that they did not provide any grounds of arrest and reasons of arrest in writing.
So grounds of arrest, there's another section of the law
Yes, my lord. Section 50, my lord, BNSS.
of the
BNSS is also there.
check. What is section 50?
My lord, I think it's CRPC.
Oh, come prepared. That's what. No, if you're going to pray on those grounds, at least take the trouble to. You see, section 50 of the BNSS is power to
Yes.
seize offensive weapons.
Yes, weapons.
When was he arrested? Is it the CRPC or BNSS applicable in this case? When was he
CRPC, my lord. Its arrest was made 2023 August. So
August.
the CRPC. My lord, if I may read section 50 of the CRPC.
BNSS will be what section?
Mm,
47. You please see, okay? Do your homework. Anyway, so you're saying that at the time of the arrest, it is the CRPC which is still applicable. Okay. What does it say?
Every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested.
Okay, fine. But when you read Article 22, this was not there, so you got confused, is it?
No, my lord,
Anyways, so let's see the grounds of arrest, memo of arrest. So you're going to come on the memo of arrest, isn't it? See yes, grounds of arrest is not informed, not the 24 hours one. Where's the memo of arrest? Page
page 22.
22, yes.
My lord, the retyped copy is at page 24. Then, my lord, if we look at the seizure and arrest memo, there is no information
Lal Thazola.
given and grounds of arrest or reasons of arrest.
Why? He is arrested because of what? So things were seized, isn't it?
Yes, my lord. However, nothing was seized from his possession.
Arrested for possession of the said article on that day. So you are the second person, Dal Tazwala.
Yes, my lord.
So, so you were arrested for the possession of 2,667 grams
Grams.
of suspected heroin. So the ground is given. So let's look at the chart sheet. The accused want Kumati, he the right fall of he brought the owner 2 lakhs of payment. From Vanal Naka. Okay.
My lord,
So that you also stated that the cease as belongs to Vanlal Kumpui witnesses. Arrest memo. Then the next page, 27, is the arrest memo. Which one are you?
then, my lord,
So which a copy of what was given to you?
arrest intimation of the accused or
Copy given? Where is the copy given to you?
arrest intimation of accused were given to their respective relative. However, my lord, it is just stated that mechanically they've just stated that the copy is given to them. However, there's no mention that if they
Arrest
actually.
of the accused were given to their respective relative.
Yes, my lord. Type
Was it
copy as
given
it-
to the accused?
No, my lord, it was not given. However, but their signature, alleged signature, was there.
Where?
They've just down below at page 23. The type copy is at page 26. This is just how they do it.
Signatures, copy received. On
Yes.
top there's copy received. Copy of this was given to both the accused persons. Okay. Now, the other
However, my
person.
lord, it was
so
not even.
you are not Lalvin Moy, so this is not. So
It was not even given to the accused person. However, they just told them when they, at the time of arrest, they just said,
then that's a
Okay.
matter of evidence. Then we'll have to see because see it's a given received copy.
yes, my lord. They are illiterate people and
Received copy is there. Then it's at its evidence stage, isn't it? How many witnesses have been
my
examined?
lord, there are 8 witnesses.
8. How many have been examined?
Out of 8 to 6 have been examined.
So you're saying nothing was seized from her, your position, isn't it?
Yes, my lord.
So where's that? Showing that nothing was seized.
My lord, if I may take your lordship to Annexure 3, is the
Annexure 3.
deposition. My lord, the seizing officer is yet to be examined.
Examined.
Yes, and the IO. Only those 2 are left. However, all the others are there.
All the others have been examined.
Yes, my lord.
Then, so
My lord, if I may take your lordship to the deposition. Deposition is at Annexure 3, page 97. It starts from page 97.
97.
My lord, it starts from 97. However, my lord, the operative portion is at 99. Cross-examination.
Yes. Who is this person? This is the
The-
JMFC.
97 is the JMFC.
Ah,
My lord, I would like to take your lordship to page 99.
99. Okay. He is the civilian witness.
Yeah, no, my lord. He's the registered owner of the
Okay,
Yoda,
okay,
the
okay.
seized vehicle. Then, my lord, if I may read the cross-examination.
Yes.
It is the fact that Exhibit PC is only motor in cold tuner and not the sale deed. It is the fact that I have no knowledge whether the involved vehicle, Tata Yoda vehicle, was used for transporting the seized heroin, nor the seized heroin was recovered from the involved vehicle. It is the fact that in Exhibit P5, there is no mentioning for what purpose the money was transferred to me by one Vanal Kongpuye. I did not exhibit any documents to prove that I sold the involved vehicle to accused Van Koma. Then, my lord, in the next one, it number 2, cross-examination by DL for accused, who is the instant applicant. Number 2, it is the fact that from my personal knowledge, Lal Chazwala did not have any involvement with the seized vehicle and seized heroin. My lord, this is not relevant. The next point, Number 5. It is a fact that I have no documentary proof showing that one person named Valan Kumpui had bought a vehicle for accused Vankuma or accused La Chazwala. It is a fact that the owner of the vehicle is not neither Vankuma nor Lal Chazwala.
Who is the owner?
The registered owner is this one, this witness, Valan Waka. My lord, the next one at page 101 is the civilian witness. My lord, if I may read the cross-examination. It is a fact that there was no carton box inside the green and yellow second-hand bail. Then, my lord, in the seizure and arrest memo, it was stated that there is a green and yellow second-hand bail. Number 2, it is a fact that I personally do not know the connection of the accused persons with the involved vehicle. It is a fact that I did not see the carton box used for keeping the seized heroin shown in the inventory photographs at the PO, and it was not seized in my presence. That, my lord, the civilian witness even stated that it was not seized in his presence, the essay.
Those are all the evidence which are, so anyway, so the seizure witness is not examined, so what?
Then, my lord, if I may continue to read. Number 6, it is a fact that at the time of seizing, the accused person did not disclose anything about the transportation or possessing of the essay in my presence. It is a fact that the seizing officer did not wear uniform. It is a fact that the arresting...
It's both the accused persons.
Yes, my lord. These cross-examination is for both the accused. They've combined. My lord, number 8 is... it is a fact that the arresting officer did not inform grounds of their arrest to the accused persons. Intimation of arrest of the accused person were also not given to their relatives during their arrest in my presence. That, my lord.
In his presence, is it required, the law?
Yes, my lord, it is.
In the presence?
Yes, civilian witness. These are the seizure witnesses, my lord.
So
That
in the, so grounds of arrest has to be given in the presence of the,
Yes, my lord.
where?
If they were arrested, at the time of their arrest, my lord, they were the arresting witness and the seizure witnesses. They ought to be given. And in the seizure and then in the report of seizure and arrest, they stated that intimation is given to their relatives. That's usually how they do it. But then who did they give it to? No, nothing was specified. If they actually give it, then they give the name, address, phone number, and their signature. However, nothing was done in this case. That, my lord, they have violated the proceedings of arrest as mandated by the law. It is a fact that I have no knowledge about the involvement of the two accused persons in connection
Okay,
with this.
rest of let the trial court see whether they are guilty or not. Why are we looking into this, huh?
That, my lord,
Because your name is not specified here. Accused persons, then the other accused persons will immediately come in this thing on bail also, if we look at this, because it's not, your name has not been specified, this person, isn't it? Both the accused persons, huh?
yes.
Yes, then?
That, my lord, I have just read out
47.
the grounds of arrest.
50 CRPC of, so when was, the BNSS is applicable, I think from the month of July,
Yes,
2023?
2024, my lord. BNSS is 2022, but I think, as per my knowledge, it came into effect on 1st July of 2024.
24, is it? Okay, whatever, which year. Yes, okay. So it is the CRPC is still applicable. But here,
Then, my lord, in the evidence itself, that there is clear violation of Article 22, which I read before, that they shouldn't be, who is arrested shall be detained in custody without being informed.
Now
They-
you have read the correct one, not the 24 hours one.
My lord,
Is it?
I was not reading the clause 1 because it was up.
Huh. That's why, no, when you read Article 22, 24 hours arrest should be what? Grounds of arrest, they have not produced, nothing is here. Anyways,
Yes, my lord.
now
I've
you have
just-
read the correct portion.
Yes, my lord. Even the prosecution witnesses have admitted that the grounds of arrest, and it was put on record, which is this is the court records before the trial judge, which is admissible. That they have admitted on record that the grounds of arrest or
Not in their presence.
was not
Given to them in their
yes.
presence. They did not
My lord,
see.
as far as yes, their knowledge.
So,
However, the prosecution in the charge sheet has not proved anything that a grounds of arrest or reasons of arrest was given to the
who's the arresting officer?
SI Lal Nunfela.
Has he been examined?
No, he's not.
Okay.
He's about to come with the IO. Zhou Tan Duang Jian Shang is also there. Is the IO, investigating officer. Then, my lord, it is proved that there is a clear violation of Article 22 and also
Read with
uh,
section?
read with Section 50 of the CRPC. And then, my lord, to substantiate my point and argument, if I may rely on Supreme Court citation.
So many citations are the latest one, not
Yes,
just skip one.
I need not, then, my lord, as you're well aware of.
Give. What I see what. Give me the citation at least.
Prabir N. Vihan and.
Citation.
Yes, my lord.
Give.
My lord, we had submitted citation memo.
So give.
Uh,
Report it in what?
uh, 2024 8 SCC 254.
You're relying on para?
Para 20, my lord, from para 20.
What is para 20?
The right to life. The right to life and personal liberty is the most
This we know, but right to life, right to this, that we know. Grounds of arrest, what are the grounds of arrest? Where's that?
No, my lord, para 21.
Para?
Para 21. The next one. The right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the accused and the grant of initial police custody remand to the accused. Then, my lord, if I may go to the another operative portion at para 29. Hence, we have no hesitation in reiterating.
Wait, para 29.
Yes, madam.
So here's the main part. Communicate the
Yes, my lord.
grounds of arrest.
My lord, rather, if I may start from para 28, the previous paragraph. The language used in Article 22(1) and Article 22(5) of the Constitution of India regarding the communication of the grounds is exactly the identical. Neither of the constitutional provisions require the grounds of arrest or detention, as the case may be, must be in writing. Thus, the interpretation to this important facet of the fundamental right as made by the Constitution while examining the scope of Article 22 of the Constitution of India would ipso facto apply to Article 22(1) of the Constitution.
Okay, so grounds of arrest has not been given to him in writing. That's your main ground, isn't it?
Yes,
Yes.
my lord. Hence, we have no
Okay, why? No.
hesitation in reiterating that the requirement to communicate to communicate the grounds of arrest or the grounds of detention in writing to a person arrested in connection with an offense or a person placed under preventive detention as provided under Article 22(1) and 22(5) of the Constitution of India is sacrosanct and cannot be breached under any situation.
Yes, leave it, enough.
Yes, my lord.
Oh,
Also, my lord.
oh, one more.
Yes, just one more. We had cited quite a few, but my lord, just one.
Wow.
So that I want to-
Because your main ground is ground of arrest has not been given to the accused,
Yes.
and the memo of arrest, which is supposed to be given to the accused in this case, was not given. Though
ma'am.
in the grounds of arrest, received copy is there, and the signature of the accused is also there, received copy. But
Yes.
you're saying that even though received copy is there and his signature is there, he has not been given a copy. I
Yes,
think
and
that's your main point.
Also, intimation was given to their relatives. It
Okay,
was
but the
stated.
name of their relative is not
Yes,
mentioned.
nothing, no signature was there. And also, there, my lord, there's no incriminating evidence against the instant applicants. And also, my lord, if I may, since they are already incarcerated for almost 2 years, and for that, if I may rely on Ravi Prakash, mm,
So you're saying 2 years, so out of 8 witnesses,
almost 2 years, my lord.
Okay.
Next,
out of 8 witnesses, 6 witnesses have been examined.
Yes,
okay?
my lord.
So now it is only the seizing officer and the case IO remaining, is it?
Yes, my lord.
Okay.
Also, my lord, if I may rely on Ravi Prakash.
Citation?
Yes, citation. 2023 SCC Online Supreme Court 1109. My lord, at para 4. My lord, para 4. As regard, my lord has got it.
Yes.
As regard to the twin conditions contained in
Wait,
section.
not yet, not yet. Two 2023-18 SCC online.
My lord, if I may give in another citation. Another.
No, 2023 SCC online. Just give the citation again. 1109.
I'll give another citation, my lord.
No, give this one. They've just found it. 2023 SCC online 1109. Is it?
Yes, 1109. And another is
Para?
para number 4.
Huh.
As regard.
Yes, please read.
As regard to the twin conditions contained in Section 37 of the NDNPS Act, learned counsel for the respondent state has been duly that the first condition stands complied with. So far as the second condition, formation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution.
Okay, 3 years. So now you were arrested when?
My lord, August 3rd, 2023. Yes, my lord, August 3rd, 3/8/2023.
So almost 2 years,
Almost
not 2
2
years.
years.
Yes. Okay, fine. Next.
Uh,
Any other point?
Yes, my lord, and that, my lord, the prolonged
Yes,
incarceration.
prolonged, you have mentioned. So
Yes,
now
the
your years is almost 2 years. Huh?
Yes, the conditional liberty must
Yes,
override
yes,
the
21,
statutory.
21.
Yes,
huh.
my lord, and also, my lord. My lord, if I may.
Yes. Coordinate bench of this court, is it?
No, my
No.
lord. The Supreme Court.
It's not reported or what? Why is it? Anyways,
Then, my lord,
this is,
my lord, first, if I may refer to Nitish Adhikari.
so now the facts of this case here is that he was in custody for a period of 1 year, 7 months.
Yes, my
And
lord.
only one witness has been examined, isn't it?
Yes,
So,
my lord.
in yours, out of 8, 4 examined, 2 is remaining, case IO and this. So I don't think this will be applicable in your case. Next. The
But my
other
lord,
one?
the trial will be a bit longer because this is just the prosecution witnesses. There will be 313 defense evidence, final hearing.
Even then,
General, yes.
this court, the apex court, only one witness has been examined.
Yes, my lord.
Then next,
Yes,
the other
the
judgment.
other one is that, my lord.
What are the grounds?
My lord, it's almost the same as that. Para number 3. It appears that some of the occupants of Honda City car, including Praveen Moria, alias Puneet Moria, have
2.5 years.
Yes, my
And the
lord.
trial is yet to commence.
Yes, my lord.
So facts are different. The yours trial has already commenced.
But the,
Out of 6, 6 witnesses have been examined. Here, he's been in custody for more than 2.5 years, and trial has not commenced yet. So when you give citations, give citations that are relevant for your case, not any citation. Okay.
my lord,
Anyways,
to us, it's quite relevant. However, it's up to your lordship.
no, I'm just saying when you cite those cases, how is it applicable in your case? That we have to see. No?
Yes,
Yes.
my lord.
Okay. Fine. Good. Anything else?
The-
Prosecution.
Please, Your Lordship, the first point, if I'm not mistaken, that my learned friend have taken is that,
Grounds
the-
of arrest not given.
yes, ground of arrest is not given. Now, in page number 23, which my learned friend have already pointed out, Your Lordship, copy received, signed by Latazwala, the present applicant. It's written in black and white. Now, reading the whole thing, I have seen that there are basic facts as to how the arrest was made. Now, coming to the judgment which is rendered by the Apex Court Authority, my learned friend have already gave a
2024,
citation that, yes, 2024-8 SCC 254, para 48. May I read, Your Lordship? It may be reiterated at the cost of repetition that there is a significant difference in the phrase reason of arrest and grounds of arrest. The reason for arrest, as indicated in arrest memo, in that case, are purely formal offense for proper investigation to prevent the accused from causing evidence of the offense to disappear, tempering, etc., etc. Now, in page number 23, we have seen in this paragraph of the Apex Court Authority, it has stated that it has to contain a basic facts as to how the arrest is made. Now, it contains all the basic facts, and it's written in black and white. It's signed, and the copy is delivered. So they cannot take the plea of the plea of the grounds of arrest not being furnished. Now, second point on ground of arrest, my second argument is that they were arrested on 3rd August 2023. Now, even though the statute is very clear, the Apex Court in the first case, that is Pankaj Bansal case, have laid down the constitutional validity of the Article 22 of the Constitution of India in this type of cases. Now, that was rendered on October 2023. So it cannot have a retrospective effect.
There's a word mentioned henceforth in the
Henceforth,
judgment.
yes. Provided thus in presently in state of Karnataka versus Hemanta Datta, the state of Karnataka is coming back to whether it will have a retrospective or prospective effect. So that is in consideration before the Apex Court Authority.
See, the judgment
Yes,
Mentions henceforth.
yes,
So
yes.
it is after the pronouncement of the
Yes,
judge.
yes. So they cannot take that ground and take the benefit of the citation which my learned friend have cited. And my learned friend have also taken the ground that uh, getting your lordship attention to the PW number 5, that is the registered owner's evidence, that Lal Chhazwala do not have any evidence, involvement in the case. He do not know. But who knows? I do not know the driver of the car which I have already sold. I do not keep track. So it's not benefiting him. And your lordship, as your lordship has already pointed out, all the cases that is cited that delay in trial have no relevance in the case, because the factual situation in that case and the present situation, as already pointed out, is totally different. Now, being that, your lordship, the embargo of section 37, the twin condition, would come into picture. Now, your lordship, I have gone through the petition. Nowhere it is written that the applicant is innocent of the crime. Nowhere. I have gone through from paragraph number 1 till the prayer portion. Nowhere it is mentioned that he is innocent of the crime. So there is nothing on record and no submission made to show that he is not guilty of the offense at this stage, your lordship. So my humble prayer is not to release the present applicant on bail, considering the nature of the offense. I rest my case, your lordship.
Yes.
My lord, if I may be given time to reply to the retrospective part, that is not applicable.
No, henceforth it's there.
My lord, there is one citation, Supreme Court ruling, judgment delivered by Sudhanshu Dhulia and Justice, which is reported in 2025, INSC
okay.
278.
Uh,
It's a para number
2025?
2025, INSC 278. This is a judgment delivered by Justice
What does it
Sudhanshu
say?
Dhulia and Justice Ujjal Bhuyan.
What does it say?
My lord, the operative portion is at page para 3. My lord, I will just
The parties, name of the parties?
para 3, the second paragraph.
Okay, name of the parties?
Kanishk Sinha and another versus the state of Bengal, West Bengal and another. My lord, para 3, the next paragraph. The
Wait, let us find it first.
(2025) INSC 278. Kanishk Sinha and another versus the state of West Bengal and another.
No, this is different. Anyway, what does it say? Give me a copy of the judgment. Now, what does it say?
It says that now the law of prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature is always prospective in nature unless it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law which is laid down by the Constitutional Court, or law as it is interpreted by the court. The judgment of the court will always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively. The prospective operation of a judgment is normally done to avoid any unnecessary burden to persons or to avoid undue hardships to those who had bona fidely done something with the understanding of law as it existed at the relevant point of time. Further, it is done not to unsettle something which has long been settled, as that
Unless
would
it
cause
specifically states,
mentioned.
isn't it?
Yes, my lord.
So you're saying that it's not mentioned?
Yes, it's not mentioned, so that's why it is applicable. My lord, one more I forgot to mention that he has 4 children, and because of his condition, his incarceration in jail, he could not take care of his children. And then, my lord, it's that page, they were placed in a TNT by the CWC, 3 of them. So, and the wife, the smallest child, out of the 4 children, the smallest child is with the wife. And then driving is their only means of subsistence. And that's why the 3 children are placed in TNT, which is put on record at page 111. That my lord,
You're well looked after.
my lord,
Chubby. Anyways, that's your submission.
obliged.
Give me the latest copy of the latest citation because it's not here. You're reading
Yes,
from
madam.
where I don't know. Yes. I've considered your submission. I'll pass the order accordingly during the course of the day. Yes. I think I'll be out by today.
Item 6.
Your Lordship, in this matter, I am the applicant. I have filed the intervention application in the present writ petition for intervention, my Lord, as one of the parties. Because, Your Lordship, this writ petition was actuated by filing of one civil suit. I had filed one civil suit in the district court.
Oh, yes, this
Yes,
matter, we
yes.
have looked into it, huh?
Wherein my claim in that civil suit was that, Your Lordship, my landed property, my LSC, which was transferred in the name of the present petitioner, who is the defendant in the civil suit, defendant number 1. I have challenged that mutation. Plus, I have also claimed for the compensation which is sanctioned in respect of that land. Because the sale deed which was made, I have challenged the sale deed. On the basis of sale deed, it was mutated in favor of the present petitioner.
So
who is
that
the
has to
defendant.
be decided, isn't it?
Exactly so, my lord. Thereafter,
So,
at the my
now
lord,
this writ petition before, who is to receive the compensation amount, before that is decided, the writ petition is filed for what? Release
so
of
see,
the
my lord,
compensation amount?
let me explain it shortly, Your Lordship. Then my civil suit was dismissed on the ground of limitation. And in the meantime, before filing of the appeal, the present petitioner had approached this honorable court by filing the present case, seeking for disbursement of that compensation by the district collector. Solely on the ground that no more case is pending. So there is no ground for holding the disbursement in her favor. And in the meantime, Your Lordship, I also preferred RFA, an appeal against the dismissal order. And that was already disposed of by this honorable court by remanding back the matter to the trial court. And now the trial court is taking up the matter and still stay of that disbursement is still there. So what is the point of pending this writ petition? It has become
That's what the
infructuous, my
question I
lord.
asked yesterday.
Yes. So
The writ petition, it's its present form and style.
now it has become
Yes,
infructuous.
anyways, counsel for the petitioner, what do you say?
Yes.
Now,
Sorry.
your writ
The reason-
petition
the
is
reason-
for her.
The reason why we filed this writ petition, Your Lordship, was that number 1, the civil suit which my learned friend was speaking about, it was dismissed in the month of November of last year. So we approached the DC saying that please release our funds as the case is no longer pending. So they did not give us any reply. Then we came to learn that the present applicant submitted one representation before the DC saying that I have intentions of filing an appeal, don't release it. Despite the fact that there is no court order. So I've submitted another representation saying that, look, there is no court order barring the disbursement. Please release the funds. Till date, they have not filed any appeal. And thereafter, it was the time of holiday. And when this honorable court first opened on the 13th of January, we immediately filed this writ petition. Even then, there was no appeal. In the month of February, no appeal. Appeal was filed by them on the last date for filing before the period of limitation in the month of March. That's how the
Okay, the
present
writ
writ petition
petition.
came into existence. Now, presently, Your Lordship, as my learned friend had mentioned, their appeal was successful and the matter was remanded for fresh hearing on limitation only after framing preliminary issues under Order 14, Rule 2. That has been done. Now the case is listed for final hearing. So if this is withdrawn at this stage, it
Liberty
will
to
only lead
file
to
afresh.
multiplicity of proceedings.
To liberty to file afresh.
No, understood, Your Lordship, but then that would only result in multiplicity of proceedings because the case
No,
which
no, but see, on limitation only, you're saying. But one of the parties, if for some reason, grounds of limitation, it's allowed or not allowed, another party will still be allowed to go and appeal. So let the matter, this district court decide as to who is entitled. Then finally, maybe ultimately in the end, it might not be you also who filed the petition or who will be entitled.
Understood,
to it.
understood.
So you withdraw the instant writ petition now because of the facts which had developed later.
yes.
Okay, and then
So whatever my
with the
learned
liberty
friend,
to file
whatever my
afresh.
learned friend had submitted were all incidents
Yes,
subsequent to the filing.
Subsequent to the
So
because
anyways,
of
yes,
the
I agree with your lordship.
subsequent,
Let the civil suit take its
yes.
own course.
Okay, so in the main, we will do in the name in writ petition. Okay, I heard Mr. Lalfaq Omar, learned counsel for the petitioner, along with Mr. B. Lalram Enga, learned counsel for the respondent. The learned counsel for the petitioner submits that due to the subsequent developments after the instant writ petition was filed, wherein a civil suit, is it? What is the matter pending? Wherein there is still a suit pending before the district court, registered as
Court of the Senior Civil Judge,
before the court of a senior civil judge, registered as
Civil Suit number 30 of 2022.
civil suit number 30 of 2021,
22, my lord.
2022, wherein the title or ownership, is it?
Title.
Yes, title, my lord.
Where in the title of the landed property covered by LSC number AZL 173 of 1987 is under challenge. The learned counsel for the petitioner prayed that the instant writ petition be withdrawn with a permission to file afresh after the disposal of the said pending civil suit. Full stop. Considering the nature of submission made by the learned counsel for the petitioner, the instant writ petition is disposed of on withdrawal with a permission to file afresh, if so advised.
Deeply.
Full stop. Wait, full stop. Then on the disposal of the said writ petition, the connected IA number 40/2025 also stands disposed of. Yes.
Deeply.
So obliged.
Item 7.
Your Lordship, before my learned friend has started the submission, I don't know whether your Lordship would
Aye.
like to recuse in this matter because in the Lok Adalat proceeding, your
Yes,
Lordship
I
had...
know this
yes.
matter. I'll recuse myself.
No,
Because
my lord.
in-
May I-
in
may I-
this matter, it was considered extensively at Lok Adalat. Okay. Now what happens? The main children of the owner, okay, of the have passed away. Now it is the wives, I think, of the who are. Yes. So the IA is what? IA is
Delay.
concerning
Delay.
delay. So all this, let it be considered by some other court.
Yes, my lord. I don't see any
Because I know
difficulty.
the parties.
I
know
don't-
the I know whichever side, whatever order made, it will not seem fair on the parties who
Very
both
well.
of them, they have sat before us in the Lok Adalat. I know
Because,
the whole history of the family.
In fact, Your Lordship, under that circumstances, in fact, it is Your Lordship who will be best to try this case, due to the fact that this is not a case of anyone challenging the Lok Adalat award. No one is challenging that.
No, so let some person who is impartial to the whole thing look. I mean, who would not appear to be influenced. Okay, because both the parties we had discussed, tried to settle. They have told, or disclosed all their problems, and then again deciding this. Even
no issues.
even the IA. If I decide, one of the parties will feel that I'm favoring the other because I know them, and that sort of thing will be there. So
It's
leave it,
fair enough,
okay?
Your Lordship. Fair enough.
Let's this matter before any other bench.
Can it
except
be
this
listed
bench.
tomorrow, Your Lordship?
So,
There's urgency.
Make it my name, okay, except this bench, we don't. No. Okay, let's this matter before any other bench on, you want it tomorrow?
Yes, my Lord.
But next week, my lord, because I have personal difficulties.
Okay.
No,
In the next week, okay, in the next week,
Can we have a date, Your Lordship?
and not before this bench.
any day
okay?
next week.
So with. Oh, okay, in the next week, on,
Today is?
this is matter before any other bench, in the next week, on, the date
fifth,
as
Your
paid
Lordship.
for the learned
5th
councils.
August.
Okay, on 5th, 8/20/25, as paid for the learned councils, and not before this bench. Then within brackets, my name. Huh.
It's obliged.
Item 8.
Your Lordship, this is being listed for the first time. Notice may be issued.
Delay.
Delay.
Heard Mr. Alpha Comma, learned counsel for the applicant slash appellant who has filed the instant application under Section 5 of the Limitation Act, read with section, by virtue of Section 30 within brackets 2 and within brackets 3 of the Employee Compensation Act, 1923, for a condonation of delay of 235 days in filing the connected appeal against the judgment and order dated 23/09/2024, passed in EC case number 5 of 2021. Full stop. Issue notice to the opposite parties through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
Deeply obliged.
Yes.
Part 2, item 12. May it please your lordship. The paper book had already been furnished to the state respondent also.
So there are quite a few paper books, paper book 1, 2. Yes, both of you can leave for the time being. Yes.
Not, in the earlier occasion, I had already been submitted the introduction.
Please submit again, I don't recollect. What was
Yes,
it?
madam.
Facts of the case.
Yes. Because there is some round of litigation in the present case, I have already submitted the introduction in this case. If I may permitted to submit again. The present RFA 53 of 2023 has been filed against judgment and order 17/5/2023, passed in CS 59 of 2016. The judgment and order is at page 846.
846. So it's in the second paper book.
In the paper book.
Second paper book.
My lord, in this judgment and order, that is the order person is at page 902. Herein, a direction has been given to Union of India. Yeah, herein, order dated 24/11/2015, passed by defendant number 2, that is Land Revenue and Settlement Department, is illegal, null and void, and the same is set aside. This order has been challenged in CS 59 of 2016.
Okay, this is Revenue Department, is it? What does the order say?
The order is at page. That's okay.
It's here.
My lord, I already read over in the last occasion, my lord.
Correct. So many cases with that. How do I? Is it page 133 in your in the index that you have given?
Yes, my lord. If I may read, my lord.
Page, because I don't recollect it all now. So many
This
other
order
cases.
has been challenged by the present respondent, private respondent number 1 in the CS.
So 133. This is the order.
Yes, my lord. Order, so and so, in compliance with Honorable Court Order dated 1/5/2015, in connection with contempt case C-16 of 2015, Saithangpui Silo versus State of Mizoram, arising out of WPC 48/2015. The authorities of Land Revenue and Settlement inquire into the matter and verify the relevant and original records of Land Revenue and Settlement with regards to allotment of settlement of the land, and the petitioner Srimati Saithangpui purchase. The following facts were revealed. Number 1, permit number 682 of 1963 allotted to Pulyan Tudaya was later partitioned into 2 parcels of the land under permit number 190 of 1974 and permit number 191 of 1974. Number 2, the area permit number 190 of 1974 was acquired by the BRTF and compensated for. Number 3, permit number 191 of 1974 was then converted into periodic pata number 1 of 1977, area 2.0 bigas by Liantudaya, thus superseding permit number 191 of 1974. The location and boundaries remain unchanged. The periodic pata number 1 of 1977 was then sold to Pubiak F. Bialzawa in the year 1977. Number 4. The periodic pata number 1 of 1977 was again mutated in favor of Pu F. Bialzawa on 25/3/1977, which was again settled under LSC 103 of 1985 in favor of F. Bialzawa. All the above transaction was done before Pu Liantudaya passed away in 22/1986. Number 5, when Pu Thanzawa, son of Liantudaya late, prayed to Chief Secretary on 6/6/2002 for redemarcation of the permit number 191 of 1974 on the plea that he was outstationed at Saitwal. It appears that he has no knowledge that his father Liantudaya had already sold this permit number 191 of 1974 to Bialzawa way back in the year 1977. Number 6, the government, without knowing the full facts, had conveyed approval for conversion of permit number 191 of 1994 into house site with 2 bigas, and later corrected area 29.48 bigas on 5/11/2003. That is, long after permit 191 of 1994 was already mutated into LSC 103 of 1985 in favor of Pu F. Bialzawa. Number 7. This was, however, clarified as under White Letter number so and so dated 10/5/2002. With regards to correction of the area of land under permit number 191/74 from 2 bigas to 29.48 bigas, it was decided by Office Memorandum number so and so dated 26/8/1991 that henceforth only the area allotted as shown in the original paper be allowed for conversion into permanent settlement, even if the boundary description covered the area. In compliance with the above instruction, the claim of land for which revenue taxes are paid only can be considered by the government. In this case, the claim of the land compensation in favor of Bialzawa was considered, for which tax are paid by the landowner. In view of Land Revenue Acts and rules pointed out above, claim of H. Thanzawa, son of Liantudaya, may be treated as a closed chapter. Since the periodic pata number 1 of 1977 was mutated in favor of F. Bialzawa, the issue of inclusion of area larger than recorded but within the boundary description of periodic pata should have been settled at the time of diversion and settlement of periodic pata into house site LSC, and whatever area might have been lying outside the recorded area but bounded by the described boundary of permit and periodic pata was already allotted to BRTF as vacant land. There appear to be no sufficient ground for claiming any right based on permit number 191 of 1974 at this stage. From the facts stated above, since the permit number 191 1974 was already converted into periodic pata number 1 1977 in superstition of the permit number 191 of 74 and later mutated in LSC number 103 of 1985 with the same location and boundaries. The permit number 191 of 1974 cannot be included and entertained in the present issue. Hence, the claim of the petitioner cannot be sustained. At page 135, this order hereby revokes government approval for conversion of permit number 191 of 74, measuring 2 bigas into house pass, white letter number, so and so dated 16/11/2002, as permit number 191 of 74 was no longer in existence in 2002. Further, the order of government convey under letter number so and so dated 10/10/2002, cancelling LSC number 103/1/1805 of 2006 belonging to Dirin Tuangi is also hereby revoked as spot verification conducted under the leadership of Director, Land Revenue and Settlement reveals that the LSC falls outside the fencing of BRTF. That is the impugned letter in the CS 59 of 2016. However, my lord, earlier to this,
Wait, before you proceed, this is in compliance with the contempt case, isn't it?
yes, my
So
lord,
there's already a matter decided, Saitangpur, I know.
my lord, earlier,
So this is in compliance of this?
my lord, the WPC 48 2015 is for spot verification of the petitioner
Okay.
land. Then they not conducted verification within a stipulated time, then contempt case has been filed. Then in pursuance to the contempt case, this order has been passed by the state.
Okay, only to conduct spot verification.
Yes, my lord. As in pursuance to contempt case, spot verification has been conducted and this order has been issued. Then this has been challenged by the present private respondent number 1, and the private respondent number 2 is defendant number 1 in the earlier case, my lord. If I may permit it to submit it again. The CS 59 of 2006 has been filed by Sai Thang Pui, the present private respondent number 1, against the present respondent number 2, H. Thanzawa, and the state by challenging this order. This order dated, I already read out this one. Then in that time, the Union of India is not a party in that case. Then order has been passed by the,
Okay, you were not a party.
we are not a party first. That is at page number 846 again. My lord, medyo welcome sa Soka. Since I already submitted in the last occasion, I am not ready for this. Page number 4, 247 is the order.
No, when you hear again, don't say already submitted, because in between we hear so many
Yes, my
cases, we
lord.
write judgments, our minds
My lord.
are completely diverted unless we hear. I don't recollect anything now.
Okay, my lord.
Page number?
247. That is the previous order.
This is after the writ petition and contempt, is it?
Yes, my
After
lord.
the spot verification?
That verification, that report, the order passed by the state has been challenged. Then this is the judgment and order. Then the relevant portion is at page 274. Uh, In fact, there is no specific order against Union of India in this case. That is the case between the present Saitangpui and Tanzawa, solely between Saitangpui and Tanzawa and the state only, my lord. Then in the order portion also, there is nothing mentioned about Union of India. If I may read, my lord. In view of what has been stated above, it is hereby decided that the order dated 24/11/2015 is illegal, null and void, and the cancellation of permit number 191 of 1974 void the said order 24/11/2015 are hereby set aside and quashed, and permit number 191 of 1974 reissued on 17/11/2003 with the approval of government is hereby revived. However, the area of the land already settled in favor of pro forma defendant number 4 and 5 shall be deducted from the area 29.48 bigas initially covered by permit number 191 of 1974. Therefore, defendant number 2 and 3 are directed to make necessary correction with regards to permit number 191 of 1974 and to demarcate the land covered by the said permit located as Zemabog Aizol to bifurcate them into two equal halves in favor of the plaintiff and the defendant number 1. Thereafter, the plaintiff number 1 shall be issued respective land pass in her name for the side fencing towards Aizol. The defendant number 2 and 3 are further directed to comply with this order within a period of 60 days from the date of this judgment and order. Here, there is nothing mentioned about Union of India. However, we are not aware of this case also. However, after disposal of this case, we received letter from the state respondent.
So this is the impugned judgment and order, isn't it?
I know the state government sent the Union of India a letter to file review petition in this, in regards to this order, my lord.
Oh, so the state was also unhappy with this order, is it? No, because their order was obviously set aside. No.
My lord, I'm sorry, I'm not preparing again for that portion, introductory portion. page, uh, page 538. 538.
The second paper book, is it?
Yes, bigger one.
538.
538 in my book.
Oh, you received this letter. Huh.
The letter addressed to Chief Engineer Project Puspak. Anilaw. Ani. Oh. 538. Yes, my lord. I'm sorry. 583. The letter addressed to Chief Engineer BRTF Project Puspak issued by Zoming Thanga Undersecretary Government of Mizoram. Subject a civil suit 59 of 2016 Saithangpui versus State of Mizoram regarding. Sir, in inviting a reference to the subject cited above, I am directed to inform you that the Senior Civil Judge 1 Aizawl District, in the order dated 5/4/2019, a copy enclosed, had decreed that the order dated 24/4/2015, which declared the permit number 191 of 1974 to be vacant land, is null and void, and it has been set aside and quashed. The court revived the permit number 191 of 1974 issued on 17/11/2003, and however declared that the area of land already settled in favor of pro forma defendant number 4 and 5, that is Sri D. Lalintluang Bethlehem and Sri Bialzawa Electric Bank shall be deducted from the area 29.48 bigas initially covered by the said permit. Therefore, this department is directed to make necessary correction with regards to permit number 191 of 1974 and to demarcate the same location as Zemabok, Aizawl, and to bifurcate it into two equal halves in favor of the plaintiff number 1, Srimati Saithangpui Sailaw, to equal note Aizawl, and defendant number 1, Sri Thanzawa Saitwal. Therefore, the plaintiff number 1 shall be issued a respective land pass in her name for the site fencing towards Aizawl. It is noticed that the BRTF Project Puspak, the occupant of the said suit land, has not been impleaded in the case. Accordingly, the additional government advocate, Aizawl District, has been requested to initiate filing review petition. Therefore, I am directed to request you to take necessary action from your end through your standing counsel immediately. Since this letter has been received by the Project Puspak, they request me to file a review petition. However, I render my legal opinion. I stated that no need to involve. Because we are not a party, then that is why I render my opinion not to interfere in the case. However, since some of the, it may be the private respondent 1 and 2 and the revenue department came to our campus and trying to slice out some portion of our land. That is why they approached me again to file review petition or whatever is appropriate. Then we have no option. Then we file RFA as third party aggrieved. Then that RFA 480. That is the order passed in RFA 16.
What does it say?
RFA 16, 2020. If,
Okay, then it was remanded back to the.
yeah, remanded back, my lord.
Okay.
From,
the trial
if I may
court.
permitted to read over from 11.
Oh.
Accordingly, the parties shall appear before the land, or from 8.
Yes. So the judgment and order dated 05/04/2019 is set aside and quashed.
Yes, my lord. Then accordingly, direction has been to given the learned in view of eight,
So that
from,
order has
from
been
para
set
8, my lord.
aside.
From para 8. In view of the above, this court is of view that the impugned judgment and order dated 5/4/2019 should be set aside and case remanded back to learned trial court for the de novo trial, wherein the appellant should be made as a party. We are appellant therein. Then the appellant should be made as a party. Number 9, the learned counsel for the parties have fairly submitted that the matter should be remanded back and the appellant should be impleaded in the suit before the learned trial court. Number 10, in view of the finding of the court and also consent given by the parties, the matter is remanded back to the learned trial court, who shall implead the appellant as a party to the suit. Accordingly, the parties shall appear before the trial court on 24/9/2021. The learned trial court shall implead the appellant as defendant number 6 and 7 in civil suit and allowed them to submit their written statement within a specific time. The appellant may also allow to cross-examine the witness if the learned trial court decided to rely upon the evidence of the witness already recorded by the trial court. As the matter has been pending a long time, the issue at hand with regards to appellant's stand being a very specific nature which may require a verification report to be made by the Land Revenue and Settlement Department. The learned trial court shall make endeavor to dispose of the civil suit as early as possible, preferable within a period of 1 year. Consequently, the judgment and order dated 5/4/2019 passed by the learned trial court in civil suit number 59 of 2006 is hereby set aside. Well, before that, my lord, my submission is at para 5
Of what?
regarding this, my lord.
Okay.
The learned CGC submits that the appellant are not in a possession of the land covered by permit number 191 of 1974. Thus, the above stand of the appellant vis-a-vis the stand taken by the respondent number 1 and 2 plaintiff before learned trial court clearly goes to show that disputed question of facts are in existence. Besides, the dispute between the respondent number 1 and 2, one side, and the respondent number 3 on the other side, in civil suit number 59 of 2016. However, civil suit number 59 of 2006 has been decided without making the appellant a party in the case. Then accordingly, my lord, the case is sent back to the lower court for trial de novo. Then we are also given a chance to submit a written statement. Then in the meantime, earlier through our RFA, the present respondent the private respondent number 2, Tanzawa, also filed WPC 155/2016 related to the same issues against Saitangpui and others. Then the same has been withdrawn because the same cause of action between the same parties had already been filed civil suit, just pending at that time, civil suit 59 of 2016. That is why the WPC 115/2016 filed by Tanzawa against Saitangpui and others has been withdrawn. Then, in the meantime, the case is remanded back to trial court. Then Union of India was given a chance to file written statement. However, my lord, there is something wrong in the judgment and order, the present impugned judgment and order.
Which the present
Yes,
judgment
my lord.
order was, you've shown it to me previously. Page,
The impugned judgment and order is page 845.
so this judgment sets aside the order
Yes, my lord.
24/11/2025.
My lord, this order has been passed in favor of the present private respondent and respondent number 1 and 2, and the order passed by the state government is set aside, my lord, set aside again. Then the trial court wrongly decided the matter. Then, my lord, for the first point, the trial court goes beyond the order dated 16/9/2022, 21 passed in RFA, because the court disposed of the matter, sent back the matter, then clearly stated what is to be done before the trial court, my lord. I already read out the relevant portion.
Is it page 274?
But I'm sorry, my handwritten note is not up here. Sorry. My lord, page number 279. Para 11, my lord. I just read out. Accordingly, parties shall appear before the Landed Trial Court on 24/9/2021. The Landed Trial Court shall implead the appellant as defendant number 6 and 7 in the suit and allow them to submit written statement within a specific time. The appellant may also be allowed to cross-examine the witnesses if the Landed Trial Court decided to rely upon the evidence of the witnesses already recorded by the Landed Trial Court. My Lord, this is the order passed by the High Court. However, the Landed Trial Court never issued specifically mentioning that whether he will retain or rely upon the evidences of the witness already be recorded by the court. However, the present respondent number 1 alone, Sai Thang Pui, submitted his examination in chief afresh. In the meantime, all the witnesses of the defendant number 1, 2, and the state and the plaintiff also retained by the court. However, there is nothing order relating to this, whether he retained or not also. However, without any permission from the court and without filing any miscellaneous application for amendment of his plaint, she amended the plaint and he changed almost all his stand taken in the earlier civil suit, my lord. That is, in the meantime, the trial court did not mention whether he will rely upon the evidences and the witness already be recorded, and also not mention about whether he will retain or rely upon the evidences. In the meantime, the Sai Thang Pui alone submitted his recast plaint without filing any proper application, that is miscellaneous application for amendment. According to the order passed by the Landed High Court, my lord, they have just to implead Union of India, then they may have changed slight portion of the prayer also. However, almost all the paragraph, all the stand taken by the plaintiff has been changed without any prior permission from the court, without filing any application for amendment of his plaint. Supposing they just changing the course title, no problem, my lord. That is as per the order. Then, in the meantime, the Sai Thang Pui, since he submitted recast plaint, he also submitted afresh his examination in chief based on her recast plaint. In the meantime, all the other witnesses' examination already recorded has been remained unchanged.
So you're saying only one person recast plaint, who?
Sai Thang Pui Silo. And based on his recast plaint, he submitted a fresh examination in chief, even though he already submitted his examination in chief in the earlier stage. Then all the other witnesses of Sai Thang Pui and witnesses of Thanjawa and 2 witnesses of state also already recorded. However, the court did not mention, the court did not pass any order whether he will retain or he will permit it the other so and so. However, they just do themselves before the court whatever they want, my lord. That is one point, my lord. Then that ultimately cause the evidence which is contradictory. The evidence clearly shows that the statement of Sai Thang Pui alone also contradicted to each other, and Thanjawa written statement and his cross-examination in chief is totally different. It's different to each other. However, there is no specific direction from the court whether he will retain or rely upon the evidence already recorded. That is the main reason for biasness has been shown in favor of the respondent, the present respondent, my lord. Then in the meantime, Judge the learned trial judge kept in abeyance 6 months' time after final hearing has been conducted. He just passed order after 6 months from the date of final hearing has been begun. That is also a violation of the prevailing rules, my lord. That is one of my point. And number two, then regarding this, I have citation. Without filing any application, the parties are not permitted to recast his claim. But my lord, I may be submitted in a lot, the citation. Prior to recast claim, my lord, the plaintiff already submitted her examination in chief based on her plaint on 28/11/2017 and cross-examined by counsel for the defendant on 23/5/2018. My lord, I don't know how to say, the earlier examination in chief and the earlier plain and the recast plain and the new examination is totally different. That's what I want to show that, my lord. If I may permit it to.
So, earlier evidence adduced by the plaintiff, is it?
Now the present private respondent number 1. Then before that, my lord, I maybe highlight by developing her case, incorporating some new development by changing almost all the stand take in the old plane without permission from the court. Then plaintiff at that time, that is the Saithangpui has 3 witnesses at that time. All their examination in chief based on the old plane. But after recast of his plane, no witness has been called for producing further examination, my lord. They retain all the other witness examination based on the old plane. Then witness Van Laltani submitted their examination in chief based on the old plane, and the written statement also filed by the state government. They have 2 witnesses, Director Brin Zamlawai and Undersecretary Martin Lalupui. Then both of them also filed written statement. Based on their written statement, the examination in chief as well as cross-examination has been done. However, after recast plane, no opportunity has been given to them. Then in the meantime, Tanzawa, now the present respondent number 2, also adduced evidence before the court based on his old plane. Now, however, his stand taken in his examination in chief is totally different.
The present respondent number 1, is it?
Now the private respondent number 2, Tanzawa.
2.
That is why the learned trial court not conducted the case as a trial de novo properly. That is why there are so many contradictory statements which cannot be trustworthy from the eye of law, my lord. That is why the judgment and order, impugned judgment and order is liable to set aside in courts, my lord. Then, if I may permitted to go one examination one by one, my lord, or I'll broadly speaking.
Where? Page
number 185.
That is the evidence.
Nghe cái gì nó mà sao cả ông đâu chứ chứ cái gì kiểm định gì. 185 is examination in chief of the Sai Thang Pui.
Saitangpui is the present respondent number 1.
1. Tanzawi is present respondent number 2. My lord, in the earlier suit, the issue is between the Sai Thang Pui and Tanzawa. Then their file FIR also. It should be clear from the written statement of Tanzawa also, my lord. Then the examination of Sai Thang Pui, examination is in chief of Sai Thang Pui already submitted based on his old plan. However, later on, he filed recast plan and without any specific direction, he just submitted a new examination in chief. Then I don't know which provision of law has been followed by the Landed Trial Court, my lord. That is why it's liable to set aside it first. Then there is nothing to say that about that the earlier one will be cancelled or not also. True examination in chief has been submitted by Sai Thang Pui in the present case. One of his examination in chief is at page 185.
Page
185.
Oh, 185, the page is already here, you had mentioned that. So this is the second examination in chief. Is it
This
this
one
is
is
the
second
second
one.
one?
Yeah,
Then
second one.
previously there was one. So they're different?
The differences is, my lord, in the plane also from para 9. Para 9.
Prayer portion also different.
Para 9, para 26, para 27, 29, 30, and 30 to 35 is totally different from the old plane. Para 1 in the old plane and recast plane is same. It's just different. Para 9. Para 9. Page number 5. Page, my lord.
187.
First page is the old plane, my lord, from page number 1. Page para 1 is same, true same. 9 is different, my lord. Page 5. The recast, if I compare, my lord, recast plane is based on 283. In para 9 in the old plane, my lord, that is at page 5. The smaller one of the paper book. If I may read, my lord,
You're reading from page?
page
Five.
5. Para 9. That consequently taking the facts that the late father of defendant number 1 had sold only a small portion of his land as stated above. The application of defendant number 1 was approved by the state defendant, and the same was informed to him by defendant number 2 via letter dated 6/11/2002 that his application for conversion of permit number 191 of 1974 into house site was approved by the revenue authorities via letter dated 6/11/2002, but only to extent of 2 bigas, since the remaining area has been occupied by BRTF. Further, just because the defendant number 3 had conveyed approval for conversion of permit number 191 of 1974 into house site for an area of 2 bigas to defendant number 2, void letter so and so, the same cannot be construed as converting the whole land covered by permit number 1. No. Well, I'm sorry, this para is not. My lord, front 26, my lord. Para 26, I'm sorry.
Para 26.
In the old plane, more than 27 bigas, that is after exclusion of those settled in favor of the pro forma defendant number 4 and 5. In other words, because of the intended proposed action of the defendant number 2 and 3, it is necessary and in the interest of justice that appropriate legal recourse is taken without any delay for protection of interests of the plaintiff.
So this is the original plaint, and you're saying this is different from the second plaint of the matter was remanded back, is it?
Here, in amended place, the bigas they claim is different. In this old plane, 27 bigas. In the amended plane, they stated 25 bigas. 2 bigas difference is there. Regarding the area, my lord. That is the difference, one of the difference. In the old plane, they stated 27 bigas. In the recast, they stated 25 bigas. Then at 27, here, at para 27, my lord. The defendant number 1 having sold and transferred all his rights over the land covered by permit number 191 of 1974 in favor of the plaintiff. The plaintiff are now entitled to declare as legal and bona fide owners of the suit land, that is, the land covered by permit number 191 of 1974, excluding those settled in favor of pro forma defendant number 4 and 5. However, the instant suit is necessitated due to the illegal claim made by defendant number 1, this one. Illegal claim made by defendant number 1 for the right title over the suit land by intending to defraud the legitimate claim of the plaintiff as stated above. This is against Tanzava. However, in the amended plain, my lord.
Exact page.
Here in the old plain, the necessity of filing the case is different, my lord. Necessitated due to illegal claim made by defendant number 1 is stated in the old plain. However, in the amended plain, due to illegal claim made by the defendant number 1.
Same. Isn't it both the same?
My lords. As per my notes. Para 29, my lord. In the old plain, the cause of action in the suit arose when defendant number 1 executed a revocation of power of attorney dated 18/2/2015 and on 22/4/2015 when legal notice was issued by defendant number 1 to the defendant number 2 and 3, and the cause of action also arose when the defendant number 1, number 2 and 3 had issued the impugned order dated 24/11/2015, cancelling each earlier decision as stated earlier. The cause of action against defendant number 1 is surviving till today. This is it shows that the cause of action has been arisen between the plaintiff and the sole respondent, the private respondent only, my lord. Then, however, at para 29 in the recast plain, that it may also be pertinent to mention here that the land covered by permit number 191 of 1974, though it was earlier converted into periodic pata, was reverted back to its original form, that is the new cause of action and new development of the case. Permit number 191 of Right Order Memo number dated so and so dated 3/10/1997. Therefore, the stand taking by the defendant number 2 that the whole area of permit number 191 of 1974 was converted into periodic pata, then converted into LSG 103 of 1985, and permit number 191 of 1974 was no longer existent. In wrong and illegal cannot be allowed to stand scrutiny of law. Now, they raise a new point which they never stated in the old plain. At page number, para number 30, my lord, from 30 onwards is totally different.
Page 30, you're reading from page?
I mean, para 30, page 13 in the old plain.
Para 30, 30.
The suit land is situated at Zemabo Kaizol, and thus this court has territorial jurisdiction to try and dispose of the case. Here in the recast plain at page number 296, para 30, that it may also pertinent to mention here that permit number 191 of 1974 was never included in the award number 9 of 1989, Annexure 8, for the office complex for Project Puspak, though the same was occupied by defendant number 6 and 7 till date. In fact, the defendant number 2 had forwarded an abstract final report on demarcation verification of BRTF acquired land area at Zemabok, Block 3, along with the assessment of the rental charges via letter memo number so and so dated 25/11/2009 to the defendant number 7 and requested him to payment of rental charges amounting to rupees so and so only for the period from 1963 to 31/12/2003.
You're reading from page?
296, para 30, recast plain. The said letter also clearly stated that if the defendant number 7 required the land in future for acquisition or hire, the land may also be right to government of Mizoram, and lease cannot be considered for Block 3 without fulfilling the rental claim and acquisition of the land. My lord, here, there is specifically mentioned Block 3. In the meantime, from my knowledge, my lord, the land acquisition proceeding had already been done in the year 89. However, till date, the state government cannot give us a land certificate. Even they handed over the land certificate and handing over the suit land. However, in that list, they stated that this handling over of the land certificate should be governed by the list by the state government. However, till date, the state government unable to issue the formal land lease certificate to the BRTF. In the meantime, I don't know how they can specifically point out this block. In the meantime, this block had already been acquired as vacant land, my lord. The plaintiff also submitted in their earlier plaint regarding the acquisition of that land. Allot page 35, if I may permit it, page 35. We started from
This is a
land
letter.
acquisition.
Wait, what's the first page? This is what? What is this page 35?
started
Verification report. This is a verification
from the
report, is
smaller-
it?
Oh, yes, in verification report, my lord. At page 35, that is block 3. Now they are trying to state it, what they have land in that
But this
area.
is page 35, a verification report. So what they've verified, isn't it?
Yes,
block
my lord.
3.
At the time of land acquisition, my lord, they already verified the block 3. That is at page 35. That is the document submitted by the plaintiff in the old plain. There is no one claimant of compensation within block 3, namely F. Bialzawa. There is no land dispute within block 3. They already identified at the time of spot verification. Now, how they can target it about the block 3, how they could specifically mention about block 3 by the
Where's
present-
block 3?
block 3 of the BRTF land.
Okay. So where's it specifically mentioned?
Yes.
Where?
Here in this amended plain, my lord,
Page?
they page number 296, para 30, they can specifically mention about block 3, which they never stated in the earlier.
Okay.
My lord, para 31, in the old plane, they just stated about court fees. Then here at para 31 in the recast plane, they developed their case by inserting some new development, and he stated that is why he almost changed all the stand taken by her in the earlier
Okay.
petition.
Very different, that
Oh,
means.
totally
Okay.
different.
Now, the bits
Without
and
the permission
parts
of-
which are parts which are different, I hope you have a table. Prepare a table.
Yes,
Okay, prepare
Yes,
a
my lord.
chart. Okay.
yes, my
A
lord.
small chart like this, which
Yes,
you
my
give it
lord.
to me. Okay,
Yes.
with the page numbers.
Yes, my
It'll
lord.
be easier then to compare.
Yes, my lord.
Huh. Okay, so that's what your 1 point,
Yeah, that is.
which is not as per the judgment of this court,
Yes.
which had only said that you may be allowed to contest. Okay,
To file written statement.
and file a
you've
written
already
statement.
recorded the
And
evidence.
the evidence can be relied upon.
Oh,
Huh.
yes, that much. However, they want whatever they submitted
But the
the
steps
recast
taken,
claim.
yes, is
without-
completely different, without
without-
any
Oh,
permission,
yes, without any permission.
without filing an IA.
Here now, there are two examination in chief for Sai Thang Pui. The court never stated that which one will be relied upon by the court, Lanet Trial Court. That is what I am trying to say, my lord. Then, that they go beyond the order passed by this court. That is one point. Then the second point is, due to that, some of the witnesses, almost all witnesses except Sai Thang Pui Silo, already submitted their examination in chief based on the old plain and based on the old written statement. If I may permitted to read over the written statement filed by H. Tanzawa also, my lord, it's clearly differ to his examination in chief also. At page 178.
Hmm. 178.
That is hateful statement. State. My lord, 166, that is written
166.
statement filed by Tanzawa.
So now you have mentioned the
Tanzawa
plaint.
is-
Now this is, now you are going to point out what?
There is contradictory statement.
That you've already mentioned. I said make a table.
By my lord, that clearly shows that the written statement itself also clearly shows that what they are stand take in the earlier stage. Now, how can they totally change their stand taken by them? That is a false statement submitted before the court is punishable, my lord.
168, page 168.
Page 166 is a written statement filed by defendant number 1, Tanzawa, now the private respondent number 2. Then from on merit, my lord, para 8, that the avertment made para 1, 2, 3 of the plain are absolutely false and completely denied, as the defendant number 1 has never sold his land covered by permit number 191 of 1974 to the plaintiff at any point of time. The answering defendant came to realize that the plaintiff have fabricated a sale deed by forging the signature of the defendant number 1 without knowledge and consent. As a result, the defendant number 1 had immediately submitted FIR, first information report, against the plaintiff to the officer in charge, Bongkon PS. Number 9, the content of para 4 of the plaint is correct to the extent that the defendant number 1 is the legal heir of his father Lian Tudaya and obtained heirship certificate in respect of all properties left behind him. The content of para 5 of the plaint is utterly false and sheer concoction. It reiterated that the defendant number 1 had never sold his land covered by permit number 191 of 1974 to the plaintiff for a measly sum of rupees 20,000, and the so-called Indrem Natutlung dated 12/4/2002 is fabricated by the plaintiff number 1 herself. It is further submitted that the contention of the plaintiff are contradictory to each other on the ground inter alia that while the plaintiff stated that disputed land was purchased by them for consideration of 20,000 as per Indrem Natutlung dated 12/4/2002, while the plaintiff number 1 claimed to have purchased the said land for amount of 30 lakhs as per sale deed dated 19/11/2013. This clearly indicates that the plaintiff have never purchased the land of the defendant number 1 at any point of time. The plaintiff are put to strict proof of the contents made thereunder. 11. The content of para 6 of the plaint is half-truth and twisted facts. The plaintiff are put to strict proof of the contents made therein. 12. The avertment made in para 7, 8, 9, and 10 of the plaint are correct to the extent that the defendant number 1 is the legal and lawful owner of the land covered by permit number 191 of 1974, and the defendant number 1 has never sold his land to the plaintiff number 1 or anyone for that matter. It reiterated that the entire claim of the plaintiff in the present suit are completely incorrect and without any basis whatsoever. As the power of attorney dated 19 March 2002 executed by the defendant number 1, it is humbly submitted that the defendant number 1 has filed revocation of power of attorney on 18 February 2015 before Notary Public Aizol, Vite Notarial Registration number 32-2 dated 18/2/2015. The plaintiffs are put to strict proof of the avertment made thereunder. Number 13. That with regards to the statement in para 11, 12 of the plaint are admitted to the extent that the area of land covered by permit number 191 of 1974 belonging to the defendant number 1 was corrected from 2 bigas to 29.48 bigas. However, the plaintiff have absolutely nothing to do with the correction of the area of the land belonging to the defendant number 1. 14, with reference to the statement in para number 13 and 14 are absolutely incorrect and without any basis whatsoever. The answering defendant has neither executed deeds of agreement dated 24/10/2003 nor filed irrevocable power of attorney dated 24/10/2003 at any point of time. In fact, the defendant number 1 has no knowledge nor consent of the said document as the same was fabricated and forced the signature of the defendant number 1, and the plaintiff are put to strict proof of the content made thereunder. 15, with reference to content of para 15 of the plaint, the defendant number 1 has
So
nothing
you're
to
saying
do.
all this
Yes, my lord,
is not
16.
there in the original this thing
Yes. Then
previously?
the written statement filed by Tanzawa and his examination in chief is
So I'm
different.
saying all that, you prepare a proper table with comparison. This para is different from this para. This is different.
Yes, my lord.
Okay.
If I may
You don't
be
have to
given
re-
some more time to make a table, a chart, for easier convenience of
Uh-huh.
reading.
So you just mentioned we don't have to write the contents
Yes,
also.
my lord, right.
Just short
Yeah.
that we can page so as we
Yes.
can refer and look at
Yes,
it
my lord,
later.
I will
no?
prepare the table for easier.
Uh-huh. So you're saying it's completely different.
Yes, my lord.
Okay. Then that's one point. What's the next point?
Next point. Then this Tanzawa also submitted. However, at the pendency of the cases was passed away, his wife is adduced evidence before the court on his behalf. However, the stand taken by his wife in his examination in chief, after recast plain, I was given a chance to cross-examine and I cross-examined her, but his stand taken has been already changed at that time. Then the witness of the plaintiff,
So all not in your favor. So all of them are now
now
deposing against
all of them,
you.
including the state, are in the same stand
Okay.
to oppose to.
Saying that that land was never occupied by you. Is it? Or it was
Yes.
occupied?
Yes.
Not occupied.
Yes, not only occupying, my lord, the land, the stated land, permit number 191 of 74 was converted from 2 bigas to 28.49 bigas. Then supposing they have a land in that area, there is no space for that, my lord, within that land. In the meantime, in the year 1989, acquisition had already been done. No one challenged that acquisition proceeding of what number 1 of 1989. My lord, in the meantime, now later on, how they claim block 3, how can they specifically mention block 3? Now this is pending for issuance of land lease within that block 3. At that relevant time, the block 3 had already been acquired as per government free land. There is a letter also. There is at that time it's a forest, my lord.
Where's that letter?
My lord, they started to occupy the land from 1963. However, in 1970, they gave a temporary permit. Then later on, 89, formal acquisition has been done. Then no additional land has been occupied by them, and they never occupied the land of the private
So when you
respondent.
acquired the land, formal acquisition, at the time of acquisition of the land, what is your stand? Did the land belong to any private person?
No, my lord. One of the land, Bialzawa, the Bialzawa purchased the land from the original owner, Lian Tudaya, that is father of Tanzawa. Then, after he purchased pass number 1 of 1991, he converted into periodic pata number 1 of 1977. And the same has been converted again into LSC. In that conversion letter, they specifically mentioned that this superseded periodic pata number 1 of 1977. Then that LSC
That
has
is how
been
many
acquired.
bigas? 2 bigas?
2 bigas. It's less than 2 bigas, but for payment of revenue tax, they counted as 2 bigas. Then they stated that this superseded the LSC and house site.
So that's
Clearly
in your
stated.
favor?
Yeah, then
That order is in your favor?
that conversion into the LSC, that LSC number 103 of 85 had already been acquired by the BRTF in the name of Bialzawa. That is why there is no issue, my lord. My lord, however, due to I am not prepared very well for giving a chart, then I may be permitted.
You give me a chart later.
Oh,
This
yes,
is-
my lord.
oh, your submissions
I
I
will
know, but now that this is different, this page, just give a chart.
Yes. I'll mention the relevant portion only.
That's it?
My lord, let be taken up again on Thursday.
No, that chart though, you have already mentioned we don't have to take up that matter. Anything else? We can complete today the hearing and then the chart, this is for the easy
Okay,
reference
okay.
of this court.
Yes,
no?
my lord. Then that then the LSC of the Biazao itself clearly stated that the earlier pass number, now the issuing the question pass number 1 of 1994 had already been superseded by the Biazawa pass, and in the meantime, the land of Biazawa had already been acquired by BRTF and compensated. No issue, my lord. However, with having a knowledge regarding the block number 3 has been acquired as government free land, they are trying to go into there. That's what's my lord. Now, at the time of filing written statement,
Okay,
there is,
previously block number 3 was not mentioned.
oh yes, they
But
filed
now,
FIR also against,
recast block number 3 has been
Yeah.
mentioned, is it?
Yes,
Huh,
yes.
okay. Yes. Anything else?
Yes,
It's
my lord,
almost
there
time
are
for
so
lunch
many.
break.
Then-
What have you, this thing, is your next submission going to take time or you can continue at 2? Just about 2 minutes left for the
My
break.
lord, it may be better to give a chart and comparing each of the affidavit and examination in chief and cross examination relating to a relevant portion only. I'll be mention, not
Okay.
not read over the whole affidavit.
No, so you're being said it's different. That's what you're saying. So you have, okay, if you want to do that, we can do it. When will you be ready?
Thursday, my lord.
Thursday, 24th. Many matters have been listed.
Any date, my lord.
We'll do it in her.
If she's completed the argument,
You have completed your argument.
Not completed, my lord.
Chato, leave it. Your main point is the difference. So the difference, you give it to me in the next date. Then what else?
Yes, my lord.
So what?
Issue, wrongly decided issue number. There are so many
So let her
other
complete her
issues.
arguments. Chato, you give it to me anytime. I'll look at it myself, isn't it?
My lord, if I was permitted to submit by way of chat, unless I'll take the whole day and tomorrow also.
Okay, okay. So your main point is concerning the difference.
Different.
Besides the difference,
Number one is
nothing else.
different.
Ah.
Number two is regarding limitation decided by the lower court. Number
so-
three is the set aside of the impugned order passed by the state.
Okay.
Then,
So you can go to limitation now, leave that.
yes, my lord.
Isn't it? Or you want another date? What was your submission to be?
let her complete.
I have so many points, my lord. Especially in in issue regarding issue number 2, 3, 7, 8,
Okay,
10,
now the issue is framed.
14.
So you're saying the trial court issued fresh issues which are different from the previous issues, is it?
Yes. Because, my lord, regarding the limitation,
Okay, then we'll continue at 2. It's 1 o'clock now.
yes, my lord.
Then ultimately you give it in a written form because then we get confused. Okay, we'll meet at 2.
May I continue? During the pendency of the civil suit, 18 issues has been framed by the landed trial court. Then out of 18, I maybe go into the relevant issues with regards to Union of India. All the issues has been decided in favor of the respondent, my lord. Then regarding issue number 2 and 3, issue number 2 is cause of action. Then issue number 3 is limitation. I may be clapped together in my submission. In the plaint, according to the plaintiff, the cause of action has been arisen at para 39, page number 298. Page 298, para 35. The petition, according to petition, the plaintiff, the cause of action in this suit arose when the defendant number 1 executive revocation of power of attorney dated 18/2/2015 and 22/4/2015, and when legal notice was issued by the defendant number 1 to the defendant number 2 and 3, and cause of action also arisen when the defendant number 2 and 3 had issued the impugned order dated 24/11/2015, cancelling each earlier decision as stated earlier. The cause of action against defendant number 6 and 7 is also surviving till date, as they have illegally occupied the land of the plaintiff covered by permit number 191 of 1974 till date. Thus, the cause of action against defendant is surviving till today. They are trying to state that since the Union of India still occupied the land of the petitioner, the cause of action survived till date. However, my lord, there is no cause of action. The cause of action, which stated power of attorney as well as legal notice such and such, is between the plaintiff and the state respondent, and between the private defendant number 2, respondent number 2 only. There is no any cause of action against Union of India. Supposing, but not admitting, the Union of India occupied the land in question. However, the land has been occupied from 1963 till date, continuously. The same has been stated in my appeal, first and second paragraph. Then in the year 1970, we are given a pass, temporary departmental pass, number 1 of 1970. Then later on, formal acquisition has been done in the year 1989. That is at page 327, award number 9 of 1989.
Where is the counsel for the other side? We all both all present?
Yes, my lord, I am for the respondent number 1.
For 2.
Two is there?
My senior is for respondent number 2, my lord.
Where is
Okay, you're there, so it's okay. Is it?
Yes.
Then what about the state? They're coming?
You're coming, my lord.
Okay, we can continue then. Page 327, is it?
327, award number 9 of 1989. Wherein the name of Bialzawa, it is page number 331, serial number 48. The LSC 10385 had included in that acquisition proceeding. Then I stated earlier, this LSC already superseded the present land in question, pass number 191 of 1974. Then already compensated, then there is no more cause of action against Union of India. Then supposing, but not admitting, the Union of India occupying the land of the respondent's private respondent, my lord, the BRTF,
See, already compensated to respondent number 2, isn't it?
no, my lord, the pro forma respondent now. Pro forma respondent number 5 in civil suit.
Respondent number
Bialzawa.
5.
Bialzawa. Bialzawa purchased the land from defendant
Respondent number
number 1.
2.
Yes, my lord. Then
From
already
1 or 2?
superseded.
1.
Number 1. My lord, if I may, my lord, the pass is also enclosed by the plaintiff in the old plan, but not enclosed in the new recast plan. Okay.
Friday, then we can continue
Yes,
to
my
the
lord,
next
Friday.
date if it's required, isn't it? Yes, have you called them? We'll make it simple, heard both the parties and then we'll continue. Okay. Yes. I'll call the bell also. Yes, this, okay, we'll wait here, call the usher, huh? The parties are duly represented by both their counsels. Heard Ms. Zairam Sankwi, learned CGC for the appellants. Matter is fixed on, what is 25th, 25